Can your marital assets be legally argued as separate property? Imagine you have a house you bought before marriage or a gift you received from a relative. You might wonder if you can keep these assets separate if you divorce. Well, in family law, most assets gained during marriage are considered marital property and divided fairly. But some assets can be argued as separate property under certain rules. Assets you own before marriage are usually your separate property. For example, if you bought a car 5 years before tying the knot, that car is generally yours alone. Also, gifts or inheritances received during the marriage can stay separate if they were given specifically to one person. If you inherited money or property during the marriage, that can often be kept out of the division process. However, things get tricky when separate property mixes with marital assets. If you deposit inheritance money into a joint bank account or use it to buy a family home, it becomes harder to claim it as separate. This process is called commingling. Once assets are mixed, the court might see them as shared property. Another point to consider is if the value of a separate asset increases during the marriage. For example, if you owned a business before marriage and both of you contributed to its growth, the increased value might be divided. The key is whether the growth was due to your efforts or market factors. If active efforts caused the increase, the court might see part of that as marital property. To argue that an asset is separate property, you need clear proof. This could be documents showing the asset was acquired before marriage, kept separate, or protected by a legal agreement called a prenuptial or postnuptial agreement. These agreements specify which assets are separate and which are shared. It's also wise to keep detailed records. Save receipts, bank statements, and legal documents that support your claim. Avoid mixing separate assets with marital funds to keep your case strong. If you want to protect certain assets, talking to a family law attorney and creating a legal agreement can help clarify property rights. In the end, most assets acquired during marriage are considered marital property. But with proper documentation and careful management, it is possible to argue that some assets are separate. Knowing these rules can help you protect your property and understand what might be divided if a marriage ends.